inshallah. أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم إن الحمد لله نحمده ونستعينه ونستغفره ونعوذ بالله من شرور أنفسنا ومن سيئات أعمالنا من يهدي الله فلا مضل له ومن يضلل فلا هادي له وأشهد أن لا إله إلا الله وأشهد أن محمدا عبده ورسوله رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقهوا قولي. السلام عليكم everyone. Welcome. Jazakumullah khair for making time and taking initiative to join this conversation, inshallah. I pray that it's of benefit. So just a little bit of background. My name is Ramia Abdo Sultan. I have been a legal practitioner for the last 15 or so years, and I have a driven passion for this very dry topic of inheritance and succession laws. And I guess it was birthed out of some studies that I had conducted several years ago by way of research. And I did a thesis, I guess, and a comparative between the Australian Inheritance Code and the Islamic Inheritance Code, trying to find, I guess, a middle ground as to which system is in fact the most fair and just system, particularly to beneficiaries. And my hypothesis was that there is no justice like that of Allah subhanahu wa ta'ala. And despite us having limited freedoms as Muslims in how it is that we are to deal with our estate subsequent to our death, we in fact have greater autonomy than anyone who would otherwise be drafting a standard will, primarily because everyone is actually accounted for, and it may in fact limit one's, I guess, likelihood or chances of having their will challenged. So that's where the passion, comes from. I wanted to share my screen. If I can do that.
You should be able to, because we've made you co-host, inshallah.
Yeah.
Okay,
here we go. Okay, is that visual to everyone? Visible?
I can see it, yeah.
Great. Okay. So I wanted to start quickly, and look, this is a topic I normally conduct 3 to 4 hour seminars on this topic. It's a very, very deep topic, and I can break it down, as I said, into hours, but there are some key introductory messages that I maybe just wanted to lay out and put out there, inshallah, just to facilitate and introduce the topic, so that if we find that there is interest, perhaps we can continue the conversation in future sessions or even offline somewhere. So the first story that I wanted to reflect on is probably very similar to that of the one that Sister Sarah was sharing with us earlier. It's in relation to a sister who had actually embraced Islam in 2015. And she, became very close to some Muslim sisters. SubhanAllah, months after she had embraced Islam and taken her Shahada, she fell severely ill, and she was diagnosed with cancer, and she actually passed away several months after she took her Shahada. She had no will in place. And the key issue here is that the burial and funeral arrangements were obviously something that nobody had control over except her next of kin, namely her family, who were not aware of her embracing Islam and were not willing to hear out the fact that she embraced Islam, and she was actually cremated by her non-Muslim family. The second story is that of a young brother who passed away. Suddenly, he was a very young man, he passed away, and his family members living overseas, in Libya specifically, insisted that his body or corpse be transported back to their homeland. And to do that, one needs to obviously get embalmed in order to be transported and sent overseas. He had no will in place, so he, I guess, could not or had not previously expressed his wishes to perhaps not have to go through that process, and he was, sent back overseas. And we'll briefly touch on embalming in the slides to come, inshallah. And the third story is that of an elderly stepmother. So basically, this man's first wife had passed away. He married a second elderly lady. He passed away. He had a will, but he actually did not account for her in the will. And the beneficiary, the adult children of the deceased father, attempted, I guess, to completely exclude this particular elderly mother from the will. even from her Islamic share. And it took us, I guess, some time to mediate the situation and try to settle and convince them to, in fact, at least give her her Islamic share, which is an eighth. And alhamdulillah, it was settled at that. There was no will, there was a will left, but it did not account for her. So in essence, it was an inaccurate will, and that could cause significant issues. So why is it that we actually need a will? I guess in my experience as a lawyer, particularly in and within the community, I noticed that we are all very reactive and impulsive as humans. So we tend to, you know, attend to those really important, critical things almost when we are on our deathbeds. And I've actually had to attend hospitals to draft certain people's wills when they have, you know, been fully aware of their diagnoses, for example, and they're fully aware that they're perhaps going through that end of life process, but hadn't gotten around to draft their will. And we've had to actually sit there and draft it for them. And I always say that, you know, it's really important that we reflect on how important it is to draft our will when we are in good health, not in a vulnerable state, of you know, good and sound mental capacity, so that we are able to make the right decisions as such. Before anything else, the reason why we also need a will is because it's a command from Allah subhanahu wa ta'ala. Allah says in Surah Al-Baqarah in verse 180, if one of you facing death can leave a legacy, he should bequeath it to his parents and relatives according to the law, and this is a duty of the pious. And it is also something that was emphasized by our beloved Prophet, peace be upon him, where it was said that it is the duty of a Muslim who has anything to bequest to not let 2 nights pass without writing a will about it. So the command and the instructions are quite clear, both in our primary source being the Quran and the Prophet's instructions in the Sunnah. I guess what we have to understand as Australian Muslims is that we have many choices. And just because, you know, we do have obviously Muslim clients come and instruct us to draft a will, they don't all necessarily instruct us to draft an Islamic will. So we have many choices. You have the choice. There is no law to tell you or obligate you to have a will. So you can do, you know, nothing and leave it up to whatever the relevant states' intestacy laws will dictate. So, for example, if you only have a wife or a husband, everything is likely to go to them. If there is no spouse or partner, likely to go to the children. No children, pass to the parents, and it keeps going in an order until, if there is absolutely nobody who is present in terms of next of kin, then it may in fact end up with the state. The second option we have as Australian Muslims is that you can have a will, right? But exercise your absolute freedom as to how it is that you wish to distribute your estate. And what I mean by this is that, as far as you're concerned, you act on emotions. So, for example, I don't like my, you know, my particular mother, or I don't like this particular son, or my daughter had not been visiting me often. I'm going to exclude her or him from the will and potentially donate all my estate to a third-party charity or organization or whatever. And this does happen often, right? So we've seen in many, particularly non-Islamic wills, situations where an entire estate at times is actually left to non-primary beneficiaries. And what happens there is, obviously, we then see those very beneficiaries come back and challenge the decisions of the deceased, and then the relevant judge go back and find that this will was unfair, consider it void, and then they are likely to decide who gets what in the end. The third option is Australian Muslims, and this is the most wise and beneficial option to all of us, is that we have a will that applies the Islamic law inheritance requirements, but also complies with the Australian legal procedural requirements. So you have somewhat limited freedom. And what we mean by that is you are distributing your estate in accordance to what Allah subhanahu wa ta'ala has told us and instructed us in the Quran. So from a distribution perspective, for example, your primary beneficiaries generally are your Muslim parents, Muslim children, your Muslim spouse, and so forth. They are your primary beneficiaries. The only thing that you have somewhat freedom in as to who to distribute beyond that to is the 1/3 wasiya aspect, or the 1/3 bequest. And that is something that you can choose to donate, give, bequeath to absolutely anyone you like, be it your neighbor, be it a family member who you know is in need, a friend, a charitable cause, the cancer council, the hospital, whoever you like. That's the part, or the portion that you, by law, Islamically speaking, you have the right to deal with. And I guess what we have to understand is that the Quran promises a reward for those who obey Allah subhanahu wa ta'ala. So when we have this certainty and yaqeen that Allah subhanahu wa ta'ala knows what is best for us as humans, and we are convinced with that, and we are convinced with the fact that because we are doing what Allah subhanahu wa ta'ala has told us to, and we are not crossing the bounds of those rules, we will see what is right actually, trickle on beyond our death. So our definition of justice is never going to surpass that of Allah subhanahu wa ta'ala. So we need to be very careful and mindful of those final decisions that we come to make when we give instructions to draft our will. And I very often have, again, Muslim clients come through the door and say, we want an Islamic will, but we want this a bit tweaked, we want that instead of this. That no longer is going to be compliant to what an Islamic will is. And I have to give that warning and that disclaimer, subhanAllah. So at times we just need that refocus and redirection and acceptance that whatever it is that Allah subhanahu wa ta'ala ordered us to do is in fact what is best for us. As we just, I guess, mentioned, we have a limited freedom in what we can deal with in terms of our estate, and we only have the freedom to deal with a 1/3 portion of our net estate. So we have this notion of a limited freedom. So when we question the fact that, okay, but it's not fair, the girl gets half the boy, how is that, even though the female of today in contemporary times is generally upholding responsibilities beyond what the male should uphold. Well, the unique feature about our faith and our scripture is that it is preserved. It doesn't change according to the standards of what society would dictate. And this notion that Islam is in fact perfect, but Muslims are not. And as Muslims, we need to work towards the perfection of Islam and not the other way around. This is just a very brief visual comparative between an Australian will, as in a will that just, complies with whatever we decide and how we decide to distribute our estate, as opposed to an Islamic will or an Islamically compliant will. In the Australian system, as we noted, you have no restrictions. You can choose the beneficiaries and how much they receive, if they receive anything, in fact. The burial arrangements, you have no restrictions. We have certain restrictions on burial arrangements and funerals. So, for example, no cremation, no embalmment. Autopsies are to be objected to or avoided if possible, and so forth. Debts and taxes and funeral expenses are generally the first thing that will be taken from the estate and accounted for. And generally speaking, an Australian will or a state-based will is going to be very jurisdictional to Australia, and we can't expect that would also apply in countries abroad. So we just need to be mindful of that. So because we don't live in a Muslim country, there are certain criteria or prerequisites or conditions in order for a will to be valid. So I often get the question, especially from older clients, I've expressed my wishes to my children. I've told them, I want A, B, and C. Is that enough? No, it's not. Because according to the Australian legal system, a will must actually have certain conditions and criteria. Most importantly, it must be in writing. It must be signed by the testator, the person writing the will. It has to be dated. And the reason for the date, it's very important and very critical in that in the event that the will is challenged, which we will briefly touch on in the upcoming case, in the event that the will is challenged by any of the beneficiaries, the date is going to set the scene for when things potentially went wrong, right? Before, and the judge, or I guess, you know, the parties who are likely to decide on the situation as to whether the will is valid or not will be able to determine at what point was this will likely to have not been valid, and so forth. It also has to be witnessed by two people at the same time who are 18 years of age and of sound mind, and all parties should sign all pages of the will. The most important thing is the person who is drafting or writing the will is obviously over the age of 18 and of sound mind. And this is really critical because, again, in most matters or challenges concerning the validity of a will, they're centered around this issue of incapacity or lack of mental capacity and so forth on the part of the testator. So in this particular case, Omari and Omari in 2012, if you're ever free to do a search on it and research or have a read of it, in summary, it's a Muslim family. The mother had drafted a will, so her sons took her to their relevant lawyer, got her will drafted in accordance to Islamic law, where the boy gets double the share of the girl, and she passed away. Now, one of the daughters had sought to challenge the will on the basis that at the time in which her mother actually signed the will, she lacked mental capacity. And, you know, with evidence obviously being presented and so forth, and, you know, the matter, taking some time in the court system, it was actually, and in fact found that, yes, at the time in which the mother had signed the will, she did not possess mental capacity. Hence, the will is going to be considered void. Therefore, the mother is to be treated as having died intestate, as in without a will. And what that ended up causing was a distribution of the estate in equal parts to all the children. So the most important thing that we take from this is that we, as I said earlier on, is that when we come to draft or think about drafting our will, we need to be doing it at a very, at a very critical time in our lives, right? Not when we're very old in age, vulnerable, perhaps, have a lack of, or almost have a lack of mental capacity and so forth, be unwell and so forth. We need to be doing it at a time in which we have full control of our health, of our mental state, and more importantly also of our capacity and ability to be able to give the instructions that we wish to give to the solicitor or the practitioner who's actually going to draft that will. So as Muslims, we obviously have duties after death or post-death. Once a person dies, a Muslim generally needs to fulfill 4 primary duties for the deceased. They must be washed, they must be shrouded, a janazah is prayed for the deceased, and then the burial of the deceased takes place. They're the primary duties. Now, there are also secondary duties, and this is going to generally be the responsibility of the executor. This is the person who is going to be responsible for executing the instructions of the deceased's will, right? So this is going to be the most important person that you would come to choose in terms of following your instructions, distributing your estate, before that even potentially be responsible for your burial and funeral rights and so forth. So their duties generally are to pay all the funeral expenses, account for all the debts, execute the will, and distribute the estate to the stipulated beneficiaries in the will. What do we normally cover? What are some of the components and themes that we address in a will? So we generally do, if it is an Islamic will, I guess, we do like to state one's testimony of faith, right? If you are a Muslim, we like to generally state that in the preamble of the will. The second is that we note obviously the testator's details, so we need to obviously ensure that their name is accurate and their address is accurate, and then we note the executor details. The executor, as I noted, is going to be the most important person that you choose. Generally speaking, in a husband and wife relationship, the advice is to nominate either or to be one another's executor. but there is also, you know, a lot of importance in ensuring that there's a backup executor in the event that both of you potentially pass at the same time, or one of you are not available at the time in which, you know, the deceased passes. So it's always good to consider a secondary executor who is obviously going to be very, very well trusted, shares the same values, faith, as you are certain and have no doubts as to their ability and willingness to execute your instructions in the will. So this is a very important person. And more so importantly, it is the person who you will entrust to have a conversation with, even after you've drafted the will, even after you've given them a copy potentially of your will. You're able and comfortable to speak to them and reiterate the instructions that you've drafted or stipulated in your will, so that they are certainly going to follow those instructions no matter what. We also then note the beneficiaries' details. We then stipulate the funeral and burial rights. And this is the really important part, and we'll break that down in the following slides. But this is the part where, for example, we clearly stipulate that, you know, no autopsies are to be conducted, no embalming is to occur, potentially, you know, no cremation absolutely be carried out or performed, and that the standard Islamic ritual type of burial is to take place instead. I've seen that someone's raised their hand. I'm not sure whether I should be.
Yeah, go, whatever you like.
Please, yeah, go for it. Unmute yourself and ask. Momtaj, did you have a question? Okay, not sure. Okay, I'll just continue anyway. The other thing that is obviously going to be accounted for subsequent to, so going back to funeral and burial rights, obviously if you have pre-purchased a burial plot, this is the place to note it down. If you have specific instructions as to who is to perform your ritual ghusl, for example, who is to pray your janazah or lead your janazah prayer, who is to, you know, in terms of a close male mahram family member, is to lower you into the grave. All these intricacies, and as confronting as they may sound, this is the time that you would obviously address them and have a really deep think about how and who you would entrust to undertake these tasks. The other issue, the other aspect that is taken care of by the executor is debts and expenses are paid. And when we talk about debts, we're talking debts owed, worldly debts, and obviously debts owed to Allah. So in terms of zakat, unpaid fasts, any kafara, anything that's owed, obviously religiously speaking, is also accounted for and paid off. Then we deal with the distribution of the fixed shares to the beneficiaries. So based on the instructions that you give us in terms of who your beneficiaries are, we will come up with the relevant portions that is, you know, religiously and Islamically, you know, compliant, I guess, and we will specify them in the will as per the fixed shares that are due and owing to your primary beneficiaries. If you decide to make a charitable contribution, we also mention it, and that is the 1/3 option. And lastly, we discuss also matters of guardianship. So in the event that both you and your husband or you and your partner pass away at the same time, this is a chance to nominate a guardian. Yes, of course, these things are challengeable by law, so they're not concrete. But again, it is always better to stipulate them than not, right? It is always better to have your wishes expressed in writing than not, that in the event that these things do get challenged, there is at least something to go back to in terms of a written instruction from the deceased. I'm just going to pause there because I feel like I've been rambling on. Did anyone have any questions that they'd like to ask?
So just to clarify, back to those hadith that about having a will,
Yep.
just to clarify, is it actually a sin to not I mean, you would sort of assume that we're sort of not, you know, if we're not doing this, maybe we need to just realize that
Yeah.
we kind of are meant to be doing it. Or
Yeah, I guess the instruction is there. I won't
yeah,
necessarily say that it is a sin, right? And that you were going to be, but the instruction is there, not only from the Prophet, peace be upon him, but also a clear instruction in the Quran as a primary source as well. So when we are, nothing that makes it in the Quran is there by accident or by passing. It is there because it means it's very important. And one of those instructions is that we need to leave a will behind, right? We need to ensure that we have a will in place so that you know, our primary beneficiaries are at least aware as to how that is going to be dealt with once we pass.
Alhamdulillah. There was a question in the chat. Assalamu alaikum. I always feel I have one daughter. I don't need to worry about a will. So that's what she's thinking. But I'm always very confused about the percents outlined in the Quran. They don't ever add up to 100%.
Yeah, I mean, I guess again, I don't want to say don't you know, occupy yourself with dealing with that aspect. There are well-versed people, and look, if you want, even you can go to your local imam or scholar or sheikh who is well-versed in this particular area, or your Muslim lawyers who do know and have a background in the portion aspect, and they will be able to give you those portions. So don't if you do need, I guess, advice and guidance as to the portion distribution, then seek it. Don't hassle yourself too much, because it is very, very much based on who's living at the time in which you are drafting that will. So we need to include everyone. Do you have parents? Do you have a husband or a wife, children? Do you have boys or girls? All those factors will contribute significantly to the portions that are Islamically going to be allocated.
Okay, so someone's saying, I'm residing here and the executor of my will resides overseas. How can you help to get it executed?
Yeah, the advice is, and look, I have this, it's a big problem and it's a big issue. I completely appreciate and understand that there are newly arrived Muslims who have just settled in Australia over the last few years, and they just have no one. They've got absolutely nobody here. And yes, they do decide to nominate an executor who resides overseas, but the advice is at least have your first option as someone who is here, who can perhaps act jointly with your overseas option. And the reason being is, when you pass away, somebody needs to be the trigger to have your will executed. Somebody needs to know that, you know, okay, who do I contact? Let me contact the lawyer who perhaps drafted the will to guide me through the process. Let me contact you know, the relevant authorities or bodies to be able to undertake this process. When you have somebody who lives overseas, there are so many, so with huge issue, especially in today's climate with COVID and so forth. And executing the will itself is going to be very complex and difficult, in that they're not familiar with the standard procedures. I'm not saying that as Australians we all know what we have to do, but you have an idea. Okay, I can contact at least this relevant authority and they can guide me, whatever. So the advice is try to have that middle person. Try to at least nominate perhaps a mutual friend that is trusted, or a family member who does reside here, to at least be a secondary to the overseas executor. And yes, you can actually nominate your a trusted lawyer if you like. I personally don't opt to go onto anyone's will as an executor, but you can also have that as an option.
Alhamdulillah. So someone else is saying, thanks for taking the time to inform us. I was wondering, when do you advise we should update our wills, and when do you think we should start making wills?
Oh, look, there's no rule. I believe, from my perspective, and this was the hypothesis that I actually ended up with in my thesis, is that the moment you finish schooling, right, you're 18, and generally you're given a license to do whatever you like. You can go to here, you can go there. You're allowed and authorized by law to do certain things because now you're 18 and you're an adult. And I believe a will should be almost the same. So the moment you are an adult and you are, you know, somewhat making money, perhaps generating an income, you've got some you know, what we call assets or items that you can call as part of your estate at some point, it's quite important to consider having your will, more so also because you can address issues concerning funeral and burial rights, and you know, in terms of how often you should review your will, I would say between every 5 to 10 years, or any life-changing circumstances that may occur in between. So for example, God forbid, if you've accounted for your Muslim parents in your will, and you know, you finished your will, you've done it, and a year or two later they pass, you should reconsider amending your will. If, for example, you've had children, if you've any, God forbid, if your children have passed, it's a trigger to perhaps have your will reviewed. So life-changing circumstances and or between every 5 to 10 years.
Okay, so that answers the question. The next question. So, Assalamu alaikum, is the 1/3 allocation to charity mandatory? Oops, and I forgot a question up the top. We'll get to that one.
No, absolutely not. So the 1/3 is an option. It's a complete option, and that's the whole point. You don't have an option with your primary beneficiaries, namely being your Muslim parents, your children, spouses. You don't have an option. It's fixed. The only thing you do have an option in is that 1/3. Do you have to exercise it? No. Can you exercise part of it? Absolutely. You can exercise part or a portion of it. So for example, you know, if you want to give a specific sum to a specific charitable cause or a hospital or a friend, as long as that person is not a primary beneficiary, then you are more than free to be able to do that. So, and my advice is to be quite frank and honest. This is now your opportunity to potentially purchase your ticket to Jannah, right? So when we come to, you know, have that option, we're given that option by Allah subhanahu wa ta'ala, I guess, to buy ourselves a sadaqah jariyah that is guaranteed. This is a time to have a good think about what cause you can choose potentially that would help you in the next life. And subhanallah, as humans, we're just so, you know, I won't say greedy, but we constantly want to ensure that our beneficiaries are well and be above in, you know, in terms of being looked after. That we tend to not think about ourselves in the next life. So it is a complete option, but I heavily advise that we do consider this option for our own akhirah, right? For our own benefit.
So there's one sister, she's a revert, so she's concerned about her children. Her husband's parents are Muslim and overseas, but her parents here are not Muslim. So it's obviously of great concern to her. She would like her children to go, obviously, overseas to the Muslims, so they don't lose their deen. What advice can you give here?
Look, you can stipulate your wishes in your wills. I mean, guardianship is in the event that both of you pass at the same time. Obviously, if you're both, if one surviving parent lives, they obviously will take on guardianship. Their parenting continues; it doesn't change. So, guardianship's in the event that both of you pass. The advice is to stipulate it in a will, not to say that it won't be challenged, and it will, and usually does get challenged, particularly in revert situations, by grandparents in particular. And it's just going to then be a matter of, you know, bringing in evidence and so forth. So have that conversation with people around you, constantly reiterate your wishes that you want your children to be, I guess, looked after, raised in a Muslim home where their foundations and you know, faith and values are not compromised and so forth. And unfortunately, at times it will be a matter in which the legal system and the court systems will have to intervene and make a decision on. But it is always better to have your wishes and instructions stipulated than not, just to be on the safe ground.
Alhamdulillah. So we'll have another 2 questions, and maybe we'll move on and save one question for later. If we have a HSC debt, which I think how that works is you're not required to pay it back until you're making 55,000 a year. Will this be taken before the inheritance is distributed?
No. So generally speaking, HEX debts, if you read the fine print, generally speaking, they are waived when you die, right? So the estate is generally not bound to continue with or carry on that liability or that debt. So if you do have a substantial extra liability, you want to avoid it. You know, dying is obviously going to solve that problem. The estate does not generally carry that liability.
Oh, subhanallah. So don't know if you'll touch on this later, but in case of there being no will, would the sons still get 2 parts if they never taken any responsibility and continue to be estranged, like away from the family, even after the parent's death?
No, so if there is no will, right, generally speaking, the relevant state intestacy laws will kick in. And, you know, assuming, again, just depending on who has passed and who's survived subsequent to the deceased death. So say, for example, the wife passes and she has a husband, the husband will generally inherit. If there is no husband, the children will inherit in equal shares, generally speaking. If there are absolutely no children, so basically they'll keep going down, you know, I will touch on it, but generally speaking, it will go down in order of family and kinship and relationship. And if there is absolutely nobody left, it goes to the state. So the answer to that question is if there is no will, and the children are the recipient beneficiaries in that circumstance, they will all receive equal shares by law, generally speaking.
So, and I guess what she's saying, you know, if someone's maybe someone's gone and, you know, got on drugs or something and they've got nothing to do with the family, Islamically and by Australian law, would they still have rights to their share?
Yeah, but Islamically, things don't apply because the legal system does not recognize what Islamic law is or what Sharia is, right? So if you haven't stipulated those instructions, the court's not going to jump in and say, oh, yeah, they were Muslims and we're going to apply Islamic law. The legal system does not understand or recognize that at all.
Okay. If I get, sorry, I think, should we, what we'll do is we'll hold the questions.
Yep.
Until a bit later.
Yeah, because I really do think the next couple of slides are the you know, the climax of today's conversation. So just moving on. So, you know, these are the standard components of the will. Obviously, if you have additional instructions and wishes, they're things that can be incorporated, and we will, and we generally do incorporate them. Moving on, organ donation, right? So generally speaking, and from a legal standpoint, the 2 main ways to indicate your intention to donate your organs upon your death is either, you know, by noting it down on your driver's license, or, and this is the most, you know, the most important bit, is to register as a organ donor to the with the Australian Organ Donation Register. That is the way to do it. Now, the next of kin will still be asked whether the deceased had changed their mind since they had recorded their intention to donate their organs, right? And they must consent to the donation of the deceased organs. So if, for example, the family member or the next of kin notes that the deceased had actually changed their mind, or they didn't, or they, as the next of kin, chose not to consent to the person's organs being donated, then no donation will generally occur. So that's a legal standpoint on organ donation. From an Islamic standpoint, and this is a very broad area, there are many differences of opinion. You've got some of the hardline opinions that say absolutely no organ donation is prohibited and it's not to occur at all. And you've actually got a completely different standpoint in that, and this is the more, I guess, you know, unanimous and general standpoint, in that most scholars actually hold the opinion that organ donation is permissible given the following conditions are actually upheld. First, that the donor is not harmed by the donation. So we're talking living and deceased donation. So in the event that you are living and in the event that you have passed, right? The second condition is that the recipient requires the organ in order to live or in order to perform an essential function. So it can't just be for any reason that you're donating your organ, be it alive or in your deceased estate, just for the sake of it. It must actually go towards an essential, you know, life-sustaining purpose for the recipient. The third condition is that the donor's body, whether living or dead, is respected and treated with dignity. And this is also very critical. If there is any likelihood of, you know, the body being treated with anything that may harm, humiliate, hurt, whatever the deceased body, then this condition is not going to be met. The fourth is that the donor must give his or her organs freely, so it must not be done under duress. It must be a voluntary decision, and that obviously that the organs are not bought or sold. Now, this opinion is generally based on the well-established legal principle that is mentioned in Surah Al-Ma'idah in verse 32, in that whoever saves a life of one person, it would be as if they saved the life of all mankind. This also has been supported by a 2015 fatwa that the Grand Mufti of Australia had actually issued, which was supported by many other contemporary scholars, locally and abroad. We're talking Saudi Arabia, Jordan, Egypt, Malaysia, and so forth. So it is a very, very common opinion. In the end, it's whatever you're comfortable with, right? So I won't say that there is a right or wrong. It is whatever you're comfortable with and whatever you feel comfortable in following in terms of what sits well with you. But the opinions are there, the options are there. It's for you to make that decision in the end. Okay, moving on. Embalming, cremation, and autopsies. So embalming is generally a procedure that is legally required in order for a corpse to be transported for burial purposes. So, for example, again, if a deceased had instructed that they wish for their body to be transported back to their homeland, by law, they must be embalmed. And it's almost like, in very brief and simple terms, almost like a mummification process of the corpse in order for the corpse to be preserved and preserved well enough to travel quite a distance without it decomposing in the natural way that it would otherwise. All scholars, both classic and contemporary, agree that this is a prohibited action, Islamically speaking. So as Muslims, it is not something that is encouraged. It is in fact something that is prohibited. Sadly and unfortunately, we do have individuals and Muslims who do actually opt for this to occur. We do have various funeral or service providers who do facilitate the process of embalming, lacking any concern or consideration, obviously, for the deceased's dignity, matters around one's aura, matters around preserving and protecting one's aura and so forth. And this is really important because generally speaking, most embalmers who hold the licenses to embalm could very well be male, and you have a female who is required to go through that process and is completely stripped and placed on a table and dealt with in the most undignified, potentially, and humiliating way possible. So we need to be very cautious of this, and I often do have clients who do ask for this request. I make it very clear that it is not Islamically acceptable. And hence, it is always good to stipulate this particular request in your will and make it very clear to your family members that this is something that you do not want to occur subsequent to your death. Cremation, we all know what that is. Generally, it's involves the burning of the deceased. Again, it is something that is completely impermissible in Islam, seeing that it doesn't provide, I guess, any benefit to the deceased or to the living. And this arises out of the aspect of respecting the dignity of a human being and preserving them from harm. Now, again, in one's will, it is very important that you do stipulate clear instructions that you do not wish to be cremated. And generally speaking, the executor is bound by these clear instructions. Some states, and I believe Victoria is one of them. I am New South Wales based, but I do believe that Victoria is one of those states where, generally speaking, that wish can be something that the executor is not necessarily going to be bound by. But thinking about the executor that you nominate then becomes critical. So if you have nominated an executor who is on the same understanding, right, in terms of your faith, your beliefs, your principles and values, and you have a specific instruction in there that you do not wish to be cremated, then generally speaking, that request and that wish will be upheld. In other states, especially New South Wales and Queensland and so forth, that request is taken very seriously, in that in the event that you've given clear instructions that you want to or don't want to be cremated, those requests need to generally be upheld by the executor. So it's very important, and we do normally cover these aspects in the will. So again, that no embalming, cremation, and again, autopsies are not to be conducted on the deceased. Moving on, autopsies are generally post-mortem examinations, and they involve the dissection of the deceased body, and they're generally required, if required by law. The coroner may have requested that this is something to take place, especially if it's a suspicious death, if it's a sudden death, where the cause isn't really known and so forth. Islamically speaking, it should be avoided. And if it is legally required, the family should seek to object to any internal autopsy, and instead put forward perhaps an alternate non-invasive type of autopsy, which is sort of, all your blood tests, tissue sample, diagnostic imaging, radiological examinations and so forth, such as CT scans and MRIs. So the point is that even if autopsies are legally required, you still have the right to object to autopsies. And what we mean by object is not show up to the coroner's court in the masses and protest. There is a procedure to undertake. So there's a form that one can actually lodge with the relevant authority, noting down why it is that you wish to object, namely specifically that, it goes against, one's religious beliefs and so forth. And more often than not, these are taken into consideration, and generally speaking, the corpse is released in readiness for burial. Okay, so did anyone have any pressing questions before we move on? Because I know this part was all pretty intense.
There is a few questions, but should we leave? So there's one about the organ.
Yep.
I've got them written down. Should we leave them till the end?
Okay, yep, that's fine. We'll leave it to the end.
Have a little
yep. That's fine. No, we'll leave it to the end because there's not much. Let me go through the rest. So a lot of people, I guess, tend to sort of note that, say, what's the point of having a will? I don't own anything. And what we understand, generally speaking, when we say your estate, it generally means all tangible items that you may possess, right, or that may be in your possession. So we're talking, obviously, yes, land and property, cars, personal clothing, household furniture, sentimental items, expensive artworks, ornaments, jewelry, computers, phones, handbags of today's times. I mean, you could be carrying a handbag worth at least $1,000 in today's, times, and that's definitely something that is of value. So when we talk about things you own, we're talking about everything in their collective in terms of value, and how much they're all worth, right? That all forms generally as part of your estate. Again, this can all be unpacked very, very in very deep detail, but I won't because we're very short on time. But just be very mindful of this point, in that anything you own, generally speaking, will form part of your estate, and that also will qualify and prompt you to want to also consider having a will in place for this very reason. When the deceased passes and the executor starts to fulfill their duties under the will, they can go through the process themselves or go, through a lawyer and apply for what we call a grant of probate. And what that means is they're pretty much presenting the will to the court, noting, the details that are stipulated in the will, and seeking the authority from the court to stamp that will and say, yep, that's good to go. No objections. There's nobody, negating any issues. Nobody sort of contesting any issues. Yep, that's fine. Stamp. Now you're free to go and distribute the estate. So if there is any property that the deceased owned, if there are any, if there's money in bank accounts, safe deposit boxes, whatever it is, the executor now has legal authority to actually call on all these assets and debts and distribute the debts, distribute the estate accordingly. So the funeral and burial costs will be paid. And again, when you are giving instructions about funeral and burial rituals and rites, be very reasonable and mindful of the costs involved. You don't want costs to blow out of proportion. And I've seen this in some instances, not necessarily in the Muslim community, but especially in other communities where funerals can cost up to $50,000. So be mindful of the costs that you are, and the things that you are seeking and requesting in terms of your burial and funeral rites. All debts are accounted for and paid for first and foremost. If there is a charitable contribution that's stipulated in the will, being that 1/3, that's the first thing that's taken out of the estate. And then whatever is left over is then distributed in accordance to the share proportions that are noted in the will. So we get a common question here in that, and this is particularly relevant for, revert brothers and sisters, in that I am a Muslim and I have non-Muslim parents or siblings. Can I leave a share for them in my will? And we know, and even based on the hadith, in that a Muslim does not inherit a non-Muslim and a non-Muslim does not inherit a Muslim, right? We know that hadith is quite clear. But when we delve into that hadith, generally speaking, what that refers to is that they are not entitled to the primary shares. So as an example, if I'm a new Muslim and I have non-Muslim parents, they will not be entitled to the standard 1/6 share that my otherwise Muslim parents would have been. If they were Muslim, they would have been automatically entitled to that 1/6, right? Islamically speaking. Now, what that means though is that I then have a right to gift them from the 1/3 if I wanted to, because I have absolute freedom in that 1/3 to gift it to whoever I like. So if I want to gift my parents from something, from my estate, it should be from that 1/3. Do I have to utilize the entire third? No, it can be a part of that. I can give some to my mum, my dad, my non-Muslim mum, my non-Muslim dad, and my non-Muslim siblings, potentially family members, anyone I like and I choose to. So the point is that there is no, I guess, it's not that the rule is that they cannot inherit from the primary shares, but they can absolutely inherit from the 1/3. And listening, I guess, to contemporary scholars talking about this issue, the advice and the recommendation is, especially if you have a good relationship with your non-Muslim parents, is that you do gift them something from the 1/3. And who knows why? What's the wisdom behind that?
Maybe it will make them want to be Muslim too, because they got a present.
Yeah, that's it. So to soften their hearts, right? To soften their hearts towards Muslims, to potentially open their hearts and the doors potentially to consider Islam, and to shed a good light on Islam subsequent to your death. So that's the wisdom behind that. The other way around, if I am a Muslim and my parents are non-Muslim and they have an estate in which, I may be entitled to, can I inherit from them? Again, it goes the same way, in that in general, you can inherit from your non-Muslim parents as long as the portion you are inheriting does not exceed 1/3 of their entire estate, right? So it goes the other way around. The point is, generally speaking, it is very important to discuss these matters with your parents, especially if you have a good relationship with them, just so that things are made very clear, right? And that nobody, I guess, there are no sensitivities. And I completely appreciate and understand that some relationships are not as good as they should be, and these conversations may be very uncomfortable and very difficult to have. So be mindful of that, and especially the part about your parents inheriting from you. I think it's a relief to many people, particularly reverts, who have a very good relationship with their parents and they really want to leave them with something subsequent to their death. And there's no harm in that as long as it comes from the 1/3.
Can I just ask quickly about that? So if, for example, so me, I'm not married, I've got no Muslim thing at all, and just say I had $100,000. So what happens if I give 1/3 of that, so 33,000 to whoever, the non-Muslim family? What would happen to the other 2/3?
You have a right. I mean, again, with matters like this, to be very honest, I would seek specific fatwa
Okay.
on it. Yes. Yeah.
Okay. Cool.
And I will ask about that. Reason being is because there's no one size fits all with circumstances such as this. And it's very important that you seek clear fatwa on it so that nobody's, making the wrong decisions in a very sort of critical time.
So, and I guess that on the other hand, if your family did leave 100% to you, and obviously, you've got to accept it or whatever, would you give the other 2/3 straight to charity or something?
Charitable cause. Again, yeah. And again, it's something very important to have to ask about, inshallah.
Yeah. Okay.
And I will note it down because, again, a disclaimer that I make, I by no means assert to be a religious scholar. And I think it's very important that these questions are noted and that we do seek guidance on them.
Alhamdulillah.
Inshallah. So just moving on, we don't have long to go, inshallah. Again, if a person dies without a will, it means they have died intestate. Again, what this means is that, generally speaking, it may be a very complex situation that's been left for your beneficiaries, having to deal with not only your burial and funeral rights, but also, how are they going to administer your estate? Who's going to administer it? Access to your estate may be very limited. Accounts could be frozen until the right administrator is appointed in order to facilitate that process. And then there are issues, concerning next of kin, who steps in, becomes a war and a battle. The best thing to do is, just to safeguard the potential issues that may arise, is have a will, right? Having a will is always better. Yes, every will, legally speaking, is open to challenge, but it is always better to have a will than not to have a will. That is the key message to take from all of this. So why do we need a will? Generally speaking, it's to ensure that our estate is distributed according to Allah's laws rather than the presiding judge at court that day, right? So when we have a will in place, we are at least ensuring that we are doing what Allah subhanahu wa ta'ala has told us and what is being commanded to us through the Quran. The second important reason is because we want to ensure that our body is dealt and treated with respect and dignity and in compliance with Islamic law. So all these issues, surrounding cremation, embalming, autopsies and so forth, they can somewhat be addressed in a will than in the absence of a will. The third reason is that we want to avoid unnecessary delays for the family in distributing the estate. So having a will allows an easier facilitation of distributing the estate. The other reason is to avoid complex and expensive legal battles by people who do not fear Allah and want to make potential claims to your estate. And I can guarantee you that, generally speaking, and especially in the absence of a will, you see aside to siblings, to husband and wife, or surviving beneficiaries that you've never seen before. You see people arguing and quarreling about the pettiest of issues when it comes to how it is that we're to distribute the estate and what I'm entitled to. No, my mum promised me this. No, this was a loan. It wasn't a gift. And all these questions arise. Have it in a will. It just makes the things a lot clearer. And lastly, it gives you an opportunity to select a preferred guardian for minors. Absolutely, this issue is challengeable and it can be something that requires the intervention of the courts, but it's always better to have it there than not have it there. Leave you with these 2 tips. Discuss your will with your family, especially your beneficiaries, and always express your feelings to them. So if you've got clear instructions in there, for example, concerning your burial and funeral rights, I don't want to be cremated. I don't want this. I want this and I want that instead or whatever. Yes, they're in your will, but always talk about it. And I think death is one of those taboo subjects that we tend to avoid and, not want to talk about because, God forbid we might die. And it is the only thing that is definitely guaranteed. So once you do have a will in place and once your instructions are clearly stipulated in that will, have that conversation with your beneficiaries, with your executors, so that, you are building, I guess, a strong support for the instructions in that will, so that nobody decides to challenge anything or potentially dispute the wishes that you've noted. The last thing is that our duty is to write a will that complies with Islamic law. But if the beneficiaries decide to have a mutual agreement between them, that's okay. And what I mean by this is, say, for example, I've done what I'm required to do by Islamic law, in that I give the son double the share of the daughter. But, between them, after I've passed and after the distribution has happened, the son says, oh, I don't really want my share. I forfeit half of my share. I'll give it to you, or I'll do this. Or the sister says, I don't want my share. I want to forfeit it to my other sister who's probably not doing as well financially. That's completely okay, right? But the point is, the most important part of this all, and the part you are being tested with before Allah subhanahu wa ta'ala, is what you've put on that paper as the testator, as the person writing the will. What happens after that is not for you to be concerned about. Beware of one-size-fits-all wills. Yes, will kits are great. They're cheap. But sometimes you just need to be very careful that you haven't missed out on anything, especially procedural. Again, yes, I understand wills can be beyond one's budget at times, but it is going to be one of the most important documents that you would come to draft in your entire life. So do consider that. Keep your will up to date and keep it somewhere safe, and make sure you have discussions and conversations with your executor about your will. We've mentioned all that. If you have any questions, feel free to reach out, and I'll open the floor for questions, inshallah.
Right, I'll actually post your details, or Jeddah, when you post to the Facebook the video. Can you pop these details with the video? Do you want me to, I'll just screenshot it quickly and send it to Jeddah after, after this. Okay, so we'll go back a bit in the questions. So we're at iPhone. Here we go. If I get a lawyer to be the second, hang on. Well, no, hang on, wait, sorry.
It's all right.
And then Raphael. Yeah, we were up to that, sorry. If I get a lawyer to be the second executor, how much will this cost? And how can I trust the lawyer will act accordingly to my wishes, given the first executor is overseas?
Yeah, I can't tell how much it costs, because, these things need to be noted and agreed on. Legally speaking, there are rules in which lawyers are bound by, in terms of how much they are entitled to take from the estate in terms of their fee for administrating, executing the will and administrating the estate. By law, they have a legal duty to uphold their responsibilities as executors under the will. So look, in the event that they don't fulfill those duties, well, there are potential criminal charges for this. So that's the only protection that you have, and it's quite a significant one, in that generally speaking, they're bound by law to ensure that your wishes are clearly carried out.
Okay, so can 1/3 be assigned to pay off debt?
No, because the debts are the first thing that need to be accounted for, right? So let's assume, you have $100,000, and half of that is a debt. That's the first thing that gets taken out. Then 1/3, or if you have noted a 1/3, that's to be distributed towards a charity. That's the next thing to be taken out, 1/3 out of what's left, and then what is left over is what gets distributed to the beneficiaries. So the most important thing that needs to be accounted for in your estate is the debt. If there is no money left after the debt, then there's nothing to distribute. So it's the debt that takes priority and precedence, especially from an Islamic perspective. It's one of the most important things that need to be accounted for in order for the deceased to rest, in the next life itself. This is something that's going to be carried on their shoulder towards the next life.
Okay. Okay, so I'm a revert. You spoke earlier of bequeathing my assets to my Muslim parents. My mother is not a Muslim. Does that mean I exclude her from my will? So I think you sort of answered that one earlier anyway.
Yeah. So you can address this from your 1/3. You can gift her from your 1/3, not from your primary 1/6.
Okay, so if a woman is divorced and if she doesn't take her share, I think there's so, like a property from her ex following Islamic law, then do you think it can affect her right in Australian law?
That's not very clear.
Not very clear.
If only
I can retype that question. I'll move on to the next ones, but yeah.
Generally speaking, just a heads up,
yeah.
Being divorced obviously then waives your entitlement to a share from your husband, and the other way around, right? Both legally and Islamically. So you need to be mindful of that in the event that you've become divorced. Islamically speaking, there is no entitlement there anymore. So your will needs to be updated accordingly. In any case, generally speaking, a will is voided after a divorce anyway.
Okay. Assalamu alaikum. Does this mean that donating your kidney or organ when still alive is not permissible because it would inevitably lead you to being more careful with how you live your life afterwards, and may also lead to pain after the donation?
No, that's not what we've said is you assess the situation accordingly. So as long as those conditions are met to your circumstances, in that your life is not put at risk in the event that you donate an organ or an essential organ or whatever, then there is no issue as such, right? So the assessment is to be made on an individual and personal level. There's no, again, the conditions need to be met according to your circumstances.
Okay, so what about super? Someone's asking.
Yeah. So I didn't address super. Super is generally something that doesn't form part of the estate because you normally would have a nominated beneficiary. The advice is though just to reflect on and assess whether you have nominated the policy to have been a binding or a non-binding arrangement, and the advice is to have it as a binding arrangement. And what that means is that the trustee would normally be bound by the will, in essence, in that they will have to distribute the super in accordance to the portions that are nominated or allocated in the will. Generally speaking, though, if you have a beneficiary that's nominated under your super policy, you would also trust that they would distribute that in accordance to your instructions in the will, right?
Okay, what about our pets? Can we nominate if he takes our pets?
You can, absolutely, you can. Yes, yeah, you could put whatever instructions you like in your will. There's no there's no harm there. But again, don't forget, when you are discussing matters of responsibility, especially guardianship or guardianship over pets and so forth, you do need to have that conversation with the person you are entrusting to make sure they are willing and able to take on that responsibility also.
Yeah, because I was doing...
You don't want to have 4 kids rock up at the front of your door unannounced.
Alhamdulillah. Can we leave a share for charities for unpaid zakats that we unknowingly forgot to pay?
I'm not entirely sure about that. That is a very sort of fiqhi type of question that I would need to ask about, to be honest. But generally speaking, unpaid zakat is considered a debt that needs to be accounted for.
Alhamdulillah. What is the punishment for taking more than 1/3 inheritance from non-Muslims?
I don't know. I can't answer that.
Yeah.
We don't know.
Someone's encouraging the other person to just pay the zakat now. Can our will be something that is just written down? Will it still be accepted if it wasn't done the legal way? Yeah, so we were talking about this the other day.
Yeah, we talked about the conditions, right? So look, I think people have sort of asked the question, can I do a stat dec or a statutory declaration? No, statutory declaration has a completely different application than a will does, as does a power of attorney. So for example, a power of attorney is only applicable during one's life, and it ceases once a person dies, and it's the will that then kicks in. So a stat dec is a completely different document that has a completely different application to a will. The advice is to have a will, as long as it's compliant and those requirements are met, in that it's in writing, it is dated, witnessed, signed by the testator and everything. Then generally speaking, that's what's going to stand. There's no harm in having a side document to note very intricate details concerning one's, for example, at my funeral, I want everyone to, I wouldn't, just throwing a crazy example, I want everyone to wear white, or all those little, nitty-gritty details you can have in a separate document, but the will is what will stand.
So I guess it would be, safe to say that if there was a stat deck and your non-Muslim family didn't agree with it, it would be easily overturned. Is that?
Yeah, it's
okay.
meaningless.
Okay. Okay. Sorry, someone's comment just totally sidetracked me. Okay, what was I up to? Oh no, here we go. Okay, can you clarify the term legacies? Is this heirs inheritance as per Sharia, or is a portion of people / charities of your choosing? And if it's of your choosing, is this allocated prior Sharia and then balance as per Sharia? My brain just broke.
So the 1/3, you are free to give to anyone, any organization you choose, right? As long as they are not a primary heir. Meaning you cannot, so say for example, you've passed and you have a husband and children and parents, you cannot give them any of those shares, right? From the 1/3. You can allocate part of that third to grandchildren, if you like. You can allocate part of that third to a mosque, to a charitable cause or an organization, to a hospital, to a friend who you know is in need and needs assistance, financial assistance. So absolutely, yes, you can go outside that. It cannot actually be a primary beneficiary. And it is the first thing that is taken after debts and expenses. So debts and expenses are paid. The 1/3 charitable contribution is accounted for. Then what is left is then distributed amongst your beneficiaries.
Okay, is it okay to share your slides with sisters? As I took some screenshots. Yeah, I did too,
yeah,
actually.
That's fine.
That's
fine.
Okay, alhamdulillah. My husband is a reaver and we have 2 kids. If his mum leaves my husband more than 1/3, can he give the rest to our 2 sons equally, 1/3 each?
That's honestly, this is questionable. So I think with these questions, I will need to come back. And look, can I urge, and actually the sisters that have these questions that I've said specifically need clarification, can you please email me those questions? Because I do have direct contacts with the imams, councils and so forth. And I will seek clarification on these, because I'm not willing to answer something that I'm not...
Can you just type your email in there, because I screenshotted it? But yeah. Okay. Someone's okay. So we'll leave questions for now, because we've actually taken up. I know you've got family you need to get to and stuff. So, but yeah, look, this has been very, very interesting. Yeah. I think we need to do it again.
Yeah, look, as I said to you, I run normally a 3 to 4 hour seminar on this. It's a very dry topic, but it can get unpacked. And there are so many other areas that we would normally cover, such as misconceptions. Why does the female get half of the male? Why does the wife only get an eighth? All these, very sort of controversial questions we normally address. But yeah, we'll leave that maybe, inshallah, over a few segments, inshallah.
Okay, inshallah. Oh, just jazakallah.